Colleagues, if you could all take your seat, we have an enormous amount of work here to go through, and I guess the sooner we get started, the sooner we end. Right now, there is no end date on this, and let's hope we can get it done before Parliament dissolves. We have with us from the Department of Public Safety and Emergency Preparedness, John Davies, Director General. Welcome. Canadian Security Intelligence Service, Sherry Henderson. Welcome. Communications Secretariat Establishment, Scott Miller. Welcome. And Department of Justice, Douglas Braithwaite. Welcome. And Ms. Beecher, are you with Mr. Davis? Okay. So we also have officials available to the committee in the room. Feel free to step up as you feel the need to. We have with us super clerks and super analysts who will move us through this agenda. So without going further, we'll start with Clause 2, Liberal Amendment. Sorry. This one first. Sorry. Pursuant to Standing Order, consideration of Clause 1 short title and the preamble is postponed. The Chair calls Clause 2. So, Clause 2, moved by Liberal 1, moved by Mr. Spengeman.
Chair, thank you very much. I'd like to welcome everybody to the discussion. The first set of, I believe, 4 Liberal amendments deal essentially with the application of the Public Service Employment Act. This first Liberal amendment removes a reference to Section 48 from the definition of the term department. It is a purely technical amendment. There's going to be a later amendment proposed to remove the entire Section 48, therefore making the reference here unnecessary. Section 48 provides the employees of the review agency with the right to move to and from other departments. And the next set of Liberal amendments, as I mentioned, will cover that as well. So it deals with employee mobility. The change that's being made here is purely made to resolve incompatibilities between Section 48 and the Public Service Employment Act, which governs most other government departments.
Debate. Those in favour? Those opposed? Amendment 1 carries. Liberal 1 carries. NDP 1, I've been given a note on the Chair's ruling. This amendment aims to increase the number of members from the review agency from 6 to 8, and therefore it's inadmissible as it infringes on the financial prerogative of the Crown and requires royal recommendation. NDP 1 and PV 1, the same ruling applies. There we go. Yes. They have to move them first. Okay, I got ahead of myself. Matthew, could you move your amendment and then I can rule it out of order?
That is what I thought. So the amendment seeks to allow the body to actually do the review work in a more robust capacity by establishing more clearly the membership, and so moved.
So moved. You've heard my ruling.
And I said moved, not moved.
And that ruling applies to, does PV1 have to move as well? No. So, Madam May, welcome to the committee.
Yes, thank you, Mr. Chair. I'd like to put on record my habitual objection to the process that this committee and every other committee adopted of forcing me to come to committee with amendments rather than enjoy the rights I would have otherwise to present such amendments at report stage. Because of the peculiarities of the motion that was originally drafted by Harper PMO, and strangely the same wording applied in the next Parliament from the new PMO. But in any case, my motion has been deemed moved before I got here, because I don't have any powers on this committee other than to appear with my amendments per your request. Thank you.
Your objection is so noted. NDP 2 is up next. NDP 2.
Thank you, Chair. This, given that the Intelligence Commissioner is the first real-time oversight and not just review that we have with regards to national security in this country, I believe that it is important that the position be filled much like the Auditor General is, with a vote in Parliament, and not just on recommendation of the Governor by the Governor and Council on recommendation of the Prime Minister.
I will make note of the ruling with respect to CPC 1. If NDP 2 is adopted, CPC 1 and cannot be moved. So, debate. Mr. Picard?
Yes, briefly, a requirement that both House of Parliament approve appointments to the NSRRA is not necessary and is inconsistent with established practice. So I will suggest that to vote against.
Any further debate? Seeing none, those in favor? Those opposed? Motion defeated. If NDP 2 is defeated, so also is CPC 1. So we deal with that. Okay, the next one up is CPC 2 cannot be moved. Sorry? It can be moved. Okay. CPC 2. Mr. Paulus. No, I'm sorry, Mr. Motts.
Thank you, Mr. Chair. This requires a more detailed and specific background for members of the review agency when they are being considered for membership. And I think it's common sense that requires individuals of a national security background to sit on the review agency, the same agency that reviews national security matters.
Debate? Mr. Brusen.
It's quite a lengthy and complex system that's set up by this proposal, but perhaps the part that concerns me the most is the fact that it would involve senior intelligence officials in selecting members of the review committee. It creates a conflict as to who's participating in a selection is the very people who are going to be reviewed as well by this organization. So I actually am very concerned by this proposal and oppose it.
Any other debate? Seeing none, those in favor? Those opposed? CPC 2 is defeated. CPC 3. And that is Mr. Paulus.
Oui, Monsieur le Président. Actuellement.
Thank you, Mr. Chair. As you can see, the position of the Vice President or Vice Chair is optional. We recommend that it would be clearly a designated position, that it's not left ambiguous and leave it in limbo. It was explained to us a little bit earlier, but we feel that the Vice Chair's position is very important and it should be clearly identified as such and be designated as such. So I don't know if perhaps you get some resource there, but
In CIRA to manage its own affairs. So ultimately, it might not always be necessary to have a vice chair. They may think that it's not a necessary part of that. That would be my objection.
Debate? Further debate?
Ben,
Monsieur Dubé?
Président, moi, j'appuie l'amendement.
I support the amendment because the way that the text is proposed, we couldn't designate a vice chair. There is no VP to replace him in case of need, and I think it has to be part and parcel of a nomination process or designation process, rather than it be done by the availability of the chair each and every time. I'd like to have the advice of our experts on that, please. Well, I don't know who's responsible, but Mr. Davies or anyone else who would take it.
Yeah, if you see page 5 of the Act, section 5.1, there is a process for an acting chair, the vice chair, if there's no vice chair formally appointed. So there already is a section in the Act to cover that.
à la page désignation du vice-président, OK, ici.
Yeah.
On this page, 5.1, section 5.1, yes.
chair, there's a process to nominate an acting chair.
OK, c'est que l'article, si je ne me trompe pas.
Okay, I'm trying to find the right section of article here. Article 6, Part 6? No. 5.1, 5.1.
Président suppléant.
Ah, ici? OK.
Excuse me, would it not be reasonable for an organization of this importance and this size to have a standing vice chair?
I just think
it'd be most appropriate, in my view, that an organization like this would want that position, not wait for in case there wasn't a chair, and now we have to go through the process of finding the vice.
yeah, certainly they may want a chair or vice chair. I guess the difference here, this is a review body that's really, the governing structure is really flows from the executive director and the staff of the executive director. So this is a board that's going to meet infrequently. So the need for a running vice chair may not be there. It may be. It depends on how they want to run it. So it's not something you would necessarily need. So that's why the potential need for reserve flexibility.
Any further interventions?
OK, je reviens parce que notre amendement relevait du...
Okay, well, from line 5 onward, where it says may, in French anyway, it says may designate, and on line 5, I believe, in the French version, and line 4 in the English version, just simply put designate. Strike the word may, strike the word peut. May designate. It's still tentative, it's elective, and I think that there should be a designation, period. So
I understand them to be synonyms, but I would want to have the jury linguist look at that. I mean, it was intended to be may on the French side. Were you in the room when that was drafted?
Is this, Philippe, is this something we should be concerned about?
Proposed is could, so. Yeah. Yeah, but then it would be, it wouldn't be synced with the English. Huh?
No.
Yeah.
It's the view of the legislative clerk that there is not a drafting issue here, that it says what it says and it's clear what it says. So it's therefore the motion, the amendment before the committee is therefore clear. Is there any other debate? Mr. Mott.
I'm just curious.
Oh,
from
sorry.
The
I'm sorry. Meant to go Mr. DeBruzen and then Mr. Mott.
No, I was curious about the drafting piece. I stick to the same thing. It's not that the organization cannot have a vice chair. It may have a vice chair. It's a matter of just providing that flexibility rather than a rigid rule. So to me, it makes sense as the way it is currently set.
Mr. Mott?
From the experts, is there organizations of this size and importance already in government that have wording like this that don't include a vice chair as normal practice?
I'm not familiar with another organization that would require in law a vice chair.
Okay. Seeing no other interventions, those in favor of the amendment? Those opposed? Amendment's defeated. CPC 4. Mr. Motts.
Thank you, Chair. This requires that the chair be a full-time member. The rationale, I guess currently the chair is to work on a part-time basis, and at his or her salary level that is unacceptable, and the amount of work that this agency will conduct will likely require full-time attitude and effort.
Ms. DeBruzen.
Again, I mean, there's a similar thread that's carrying across, which is just a matter of allowing for flexibility within it. The wording as it is allows for a full-time position. It's a matter of it's something that could happen. It doesn't say, but having the stringent requirement that it be a full-time position takes away flexibility. It takes away the possibility for some suitable candidates. If I can just throw in as someone who I know working as a lawyer down in Toronto, there were a lot of people who would do, qualified people who would do part-time positions because of different things. I worked part-time. There were job shares, all sorts of flexibility, which in fact increases your opportunity to have suitable candidates. So I would say that I would keep the flexibility there. You can have a full-time person, or it will allow for a part-time position.
Mr. Bay.
Thank you, Chair. I appreciate the point that was just made, but I think having these positions be part-time or even have the possibility of them being part-time shows a lack of seriousness with regards to the review process and actually wanting to undertake it properly. I find it difficult to imagine that this kind of body would be something that someone would be involved with other work or doing other things or only part-time, and I think it's incumbent, if we really want to take the kind of accountability that's being sought with this agency seriously, then it should be a part-time position. So I support the amendment.
Mr. Motts.
We're talking about national security here. This is national security. This is why we've been given this before second reading. This is a serious issue, as Mr. Dubé has said. This is not something that you work on off the corner of your desk at all, and I believe it's critical that this individual be full-time, that his mind be engaged in this on a full-time basis. His attitude and his effort needs to be full-time, and as a result, I don't think it can be anything but.
Mr. Paulus.
Donc, c'est la même chose.
Okay.
Same argument, sir.
Those in favor? Those opposed? Motion defeated. CPC 5.
C'est la même que 4.
The amendment.
It's the same issue.
See?
Has that one been tabled then? Because it really is following what the other amendments said.
Yeah. It was, CPC 4 was defeated. Therefore, CPC 5 is now up.
Good.
Any debate? Those in favor? Those opposed? CPC 5 is defeated. CPC 6. Mr. Motts.
This amendment is designated, really no member designated as the chair can hold the position for more than 30 days. So C59 allows for a member to hold the role of the chair for 90 days. That's far too long, and a vice chair should be in place to cover off all the absences of the chair in the first place. It would be the rationale behind this particular amendment.
Debate? Ms. DeBruzen.
30 days is a very, very short period of time. 90 days is a reasonable amount of time to have there for someone to hold a space. It would just adds to an administrative burden to limit the time. It again reduces flexibility. 90 days isn't a very long period of time either. So I would suggest that the way it's worded right now is fine.
Other debate? Mr. Motts.
So, if this is too short of a time, and we've just voted against having a vice chair, it would seem to me that if we don't have a chair, for whatever reason, and that chair position is vacant, and we don't have a position of vice chair in place,
We can't, no.
because we've already been defeated, the chair isn't around to assist in that selection process of having a vice chair. So to me, it's reasonable on these sort of circumstances to have a shorter window. It seems totally reasonable to have, in those circumstances, to have that chair filled, position filled for a shorter time period.
Further debate?
I just want to add, I just want to clarify that in fact there may be a vice chair. I just want to clarify that that is still within the legislation as we've passed over it.
So just
Mr. Motz.
with the officials here, is it possible that we can appoint a vice chair inside of the 30-day window?
Mr. Davies.
Possible answer, given that it depends, it's a GIC prerogative to do that. And normally it would take more than 30 days,
Right.
especially in national security when you may need to vet the person and so on. But just to be clear, again, section 5.1 is the process for the acting chair. So if there's no chair, no vice chair, the process is there to appoint an acting chair, and then 90 days for the governor and council to appoint a chair. So there's 3 months to find a chair if, for whatever reason, the chair or vice chair are not there.
Any further debate? Those in favor of CPC 6? Those opposed? Motion defeated. Ms. Damoff, Liberal 2.
From the Canadian Bar Association concerns about the ambiguity of language surrounding the NSIRA's mandate and whether it's overly broad. So this amendment clarifies that the NSIRA has full authority to determine its own procedures, and it also removes any ambiguity about the scope of authority of the NSIRA to avoid possible dispute with other departments.
Debate? Seeing none, those in favor? Harmony is breaking out here. My goodness. Motion passed unanimously. NDP 3.
Merci, Monsieur le Président. C'est un amendement qui est...
Thank you, Mr. Chair. This is a very lengthy amendment, but it's really quite simple. It's an issue that's come back on many times during the study of the bill. The possibility of receiving complaints as to the behavior or comportment of various agencies. Foreign Affairs is not covered by this complaints mechanism, and that might be very important given consular duties. There's a sharing of information between that particular department, which can lead to the breach of rights of Canadians, particularly when they're abroad. This would allow the agency to hear complaints against or concerning external affairs, foreign affairs. And then there's the Border Agency Services, the agency. They missed an opportunity here to for oversight of this department as well. The minister was quite open to the possibility of doing so, but it would be appropriate, to my mind, that this agency, CSBA, and the office be able to hear complaints brought against border services as well.
Adds to the complaints provisions in the legislation. It's nothing earth-shattering, but ensures that we have a robust process for all agencies and ministries that might have involvement in different situations that can become problematic with regards to Canadians' rights.
Thank you, Mr. Dubé. Ms. Demo.
Thank you, Chair. And I think while we would agree in principle on the intent of the amendment, we heard that only a small part of global affairs and CBSA's work actually focuses on national security and intelligence. And so this would this bill as drafted would deal with the national security and intelligence portion of it. And I would say if there's a desire to have oversight of global affairs and CBSA, the public would be best served to put complaint mechanisms in that are tailored to their unique mandates. As it is now, the NSIRA will be focused just on a small part of what they're doing. And so it wouldn't make sense to have, in fact, we heard testimony around that it would actually slow things down for people who were complaining about things that fell outside the mandate. So we won't be supporting it as written.
Mr. Palouse.
J'aimerais avoir une explication.
Well, I'd like a bit of an explanation, if I may. Ms. Demos has already mentioned that the NDP proposal, I don't know what it has to do with national security, in fact, but perhaps our resources here could explain that to me. It's not clear at all to me if there's a link between this bill, which is a national security bill.
Understanding the amendment is for a complaints function, particularly with global affairs and CBSA. The Minister, I think, has made the point a few times that the CBSA review mechanism, including complaints functions, on a separate track, separate legislation is being worked on in that regard. And CIRA is only dealing with national security review and complaints regarding CSIS and the RCMP.
Mr. Dubé.
Yeah, thank you, Chair. If you look at the legislation, in Section 8, it specifically mentions certain aspects. So you look at reports made to the agency under the Citizenship Act, matters referred to the agency under the Section 45 of the Human Rights Act, the RCMP Act, any complaint made out of subsection 16.1, 17.1, 18.3. So what we're seeing here is, despite the fact that the majority of witnesses who did raise this point spoke in favor of what this amendment is putting forward, because despite it being a small portion of global affairs as is being advanced, this is something that goes to the heart of what was talked about, most notably in the Arar inquiry, because global affairs does play a role in how these situations play out, and moreover to simply fall on the fact that to somehow conclude that CBSA, as far as I'm concerned, acts exclusively with regards to national security. I see no other way to define what goes on at the border than to say that it's related to national security. And so I think in the meantime, there's a huge gap there. There's no accountability for CBSA. And so to have this complaint mechanism in the mandate of the agency and not expanded as many witnesses asked us to is quite disappointing, and once again just shows how the accountability and the review that we're seeking is just not being taken as seriously as the government pretends to.
Ms. Dama.
I'm wondering if Mr. Davies could clarify that anything that happens with CBSA and global affairs that does have to do with national security, such as what happened with Arar, would be covered under this legislation.
Yes, it would.
Thank you.
Mr. Motz.
Well, with this amendment proposal, I'm wondering whether there is the need to add additional staff to accomplish this, and whether there'd be, additional costs, obviously, with that, and whether the foreign affairs, global affairs, and CBSA have those resources in place already.
It would be impossible to predict. The national security mandate for global affairs and CBSA has already been said is probably small, so the number of complaints would probably be small, but there would likely be resources needed at least to sort of pressurize the system to receive complaints if that mandate was added on to NCIRA.
Mr. Dubé?
For the record, I do want to say that the RCMP is also covered by the review agency, and yet that hasn't prevented the legislation to include a complaint mechanism with regards to the RCMP. I think it's important to distinguish between the agency's ability to review these agencies and a Canadian whose rights have been impugned upon to make a complaint to the agency, to the review agency, I think is an important distinction. And once again, I fall on the witness testimony, many witnesses who did bring this up as a large gap. And more specifically with regards to CBSA, as of now, NISRA is the only body that has any oversight of, or review rather, it's an important distinction as we know, any review of CBSA. CBSA, unlike other agencies that are involved very closely with national security, have no has no specific review entity associated with it. And moreover, Chair, I would just add as a last point that in light of some of the situations we do see at the border, I think giving Canadians some kind of mechanism so that they can make these types of complaints to a body like this is absolutely appropriate. And the last point I would make, Chair, is going back to an earlier point that was made with regards to and also alluded to by Mr. Motz about staff and so forth. The amendment does make clear, as should be enshrined in the law, that the agency will not deal with complaints unless they are deemed to be not trivial, vexatious in nature, or made in bad faith. So once again, it's a gap that is there, and I see no reason why this can't be supported, other than the fact that we don't take the accountability that we claim to want to bring forward seriously.
Mr. Motz.
Is it possible, being we haven't heard from Global Affairs and CBSA, to have them just table this for the moment and bring them here to the committee to answer specifically to this particular amendment?
Are you moving that?
Sure.
I think we'd have to deal with it as a motion first to table and then in effect postpone the date. Is there any which I would think takes precedence over this? So is there any appetite? If you move the motion, then we could debate that motion and then vote on the motion and then move from there. So just before I get too far down that path, I want to check with people who actually know what they're talking about. Mr. Motz, the ruling is that your motion is actually out of order, that we cannot move that at this time. So,
is there a reason for that? So I don't make the error of having another one similar?
Because we've already started to deal with the clause. So my theorizing would have been you would have to move that motion at the beginning before we started to deal with this clause. Is that somewhat correct?
Isn't that counterintuitive? It's the conversation that brought up the issue that we don't know. But anyway, I didn't write the book.
So you are able to move a motion which postpones the consideration of the entire clause, but not this particular section alone.
Interesting.
Interesting. Are you moving your motion or are you withdrawing your motion?
Well, obviously it's inadmissible, so I'll have to withdraw my motion.
Okay. Then motion is withdrawn. So we're back to the amendment. Is there further debate on the amendment? I saw Mr. Picard waving his pen there.
Comme M. Motz l'avait dit précédemment, c'est une question de...
Mr. Mott said earlier, it's a matter of national security, and according to our specialists, the intent of the legislators on this bill is to deal specifically with national security. However, society has a larger responsibility than that. It could include customs agency complaints that should be submitted to the review, but it's not part of its mandate. It's just not part of its mandate.
Seeing none, those in favor of NDP 3? Those opposed? Motion defeated. Liberal 3, Ms. Damoff.
Chair. Again, I'm just going to mention some testimony that supports this amendment. We heard from Michael Vaughan, who said that national security activities in general are plagued with the problem of having words in a statute or directive interpreted in sometimes obscure or deeply troubling ways that may not be unearthed for years. And so this amendment requires the NSIRA to review and report on new and modified ministerial directions, and it also strengthens departmental accountability by requiring the NSIRA to review how departments implement ministerial directions.
Thank you. Mr. Dubé.
Thank you, Chair. I support the amendment. I think it's a good idea. I do want to, however, point out that it's interesting that we propose amendments on the Liberal side to increase the mandate and vote down amendments that would make the chair full-time.
Et c'est exactement la réflexion que j'avais. Merci, Mathieu.
Exactly the same idea I had, Mr. Matthews. Thank you very much.
Exactly alike. Ms. Damoff.
Sometimes.
Just to clarify, we didn't vote down an amendment to make it full-time. It can still be a full-time position. It's just, it's optional.
Okay.
We're not saying it won't be.
Any other
Thank you.
debate on Lib 3? Those in favor? Those opposed? Liberal 3 passes. CPC 7. Mr. Motz.
Yes, thank you, Chair. This particular amendment requires the minister to table to Parliament the clear outline of how these organizations work together, the NSIRA, the CSE, CSIS, and the new parliamentary committee, as well as the powers, duties, and functions of the minister. Now, intended to address the committee's confusion on the bill and how all these organizations work together is the motivation behind this. We heard repeatedly from testimony throughout C-59 that it remains unclear how the government will structure the new parliamentary committee and the NSIRA, and we still don't have a clear idea of how they will work together, and that hasn't been clarified yet. Therefore, we should have the minister provide that clarity as soon as possible, and perhaps the officials can provide us some clarity on that today, if possible, and how these bodies will work together.
Debate. Mr. Spengleman, did I see your hand?
Mr. Chair, in my view, this amendment isn't necessary because under C-59, the NSIRA expert staff already have the authority to obtain ministers' national security and intelligence responsibilities or information they're under, and why place an additional formal burden on the ministers? And equally, the NSIRA would already have the authority to publish general background information in its annual and special reports. So my submission to the committee is that this amendment is not, in fact, required.
Anything else? Paulus? Mr. Paulus?
Je comprends ce que mon collègue dit.
I understand what my colleague is saying, but we had several witnesses, as Glenn has just mentioned, that have cast some doubt on the efficiency of these relationships. So we'd like to know what is the full mandate of the minister, and many witnesses have told us that this is going to be problematic. I don't see how you view the thing from a public service point of view, but we'd like to have something clearly explained in the law.
I would just say, as it was already said, the mandate of the review body already allows it to ask for whatever it wants from any department or agency whenever it wants. Presumably, it'll already be staffed by experts who are very much familiar with the mandates and so on. There are already many annual corporate reports, annual reports and so on published by the agencies, things on websites and so on that explain the powers and duties of these agencies. So it's not clear what else you get, and maybe this is how we're reading how these words were drafted, but it's not clear what additional information you get from this amendment.
Further debate? Those in favor of CPC 7? Those opposed? Motion defeated. Amendment defeated. CPC 8. Mr. Motz.
Yes, thank you, Chair. This requires that the review agency and NSIRA take all steps possible to avoid the duplication of work. We'll cut down on the duplication, obviously, and make the groups more effective in the long run. I think the amendment seeks to have, I guess, NSIRA and the Parliamentary Committee to coordinate their work, to limit the amount of red tape and extra work provided to the agencies like CSIS and CSE, and ensure that the massive costs are reduced at least a bit to meet the administrative burden to these new groups. Parliament needs to know this issue, and I think it's a reasonable ask, or reasonable amendment.
Debate? Mr. Spengling.
If I can direct the committee's attention to clause 49, that's pages 35 to 39 of the bill. In my view, there are provisions in that clause that are very similar, if not identical, to what's being proposed. And clause 49 does a couple of things. It requires NSIRA and NCCOP to cooperate to avoid unnecessary duplication, and it also gives these two bodies explicit authority to exchange a range of classified information that's related to their reviews. So my submission to colleagues is that we do not actually need this amendment.
I'd like to hear from the officials if I could, Mr. Chair.
Okay. Mr. Davies?
Just say the spirit is there, as was mentioned. It's already contained in clause 49, the ability for them to cooperate. The other concern with the drafting of this amendment is it does not allow or authorize the exchange of classified information, and it does not remove complaints, the ability of exchange complaint information, which you would not necessarily want to do in this case. So there's two concerns there.
Any other debate? Those in favor of CPC 8? Those opposed? Amendment defeated. NDP 4. Mr. Dubé.
Merci, Monsieur le Président.
Thank you, Mr. Chair. The intent of this amendment is to ensure that the agency might be able to obtain any foreign intelligence used by the CSEC in order to act on national security issues. Currently, they have access to any documentation that the department would have in its possession. We could also argue that foreign intelligence should or could come under this definition, but this amendment seeks to ensure that there is clarity on the access to this type of information, because often they have to depend on information that is provided by our allies or another country. And the amendment, in fact, complements and supplements the clarity of the issue.
Thank you, Chair. It seems this amendment isn't necessary, and maybe officials could just clarify this for us, but foreign intelligence services already can make a disclosure to the NSIRA, and in fact, it's probably unlikely that they would likely go through our security agencies. So it seems that it's a bit redundant to actually add it into the legislation when the ability is already there, and the NSIRA could request that information anyway. So I'm just wondering if officials could clarify if we require these two words to be added to it, or if that ability already exists the way it's written.
Mr. Davies?
Yes, you are correct. We do not believe that you need legislative authority for the NSIRA to receive classified information from a foreign intelligence agency, should that agency want to give NSIRA that information. Normally, the NSIRA would get it directly from any of the departments and agencies in Canadian departments and agencies. They have full access to that. Anything the agencies have, other than cabinet conferences, NSIRA can get.
Any other debate? Sir? Oh, Mr. Dubé, didn't see your finger.
Thank you, Chair. I anticipated that argument, and that's why, as I said, and I'll repeat, that I believe the greater clarity is always better when it comes to a body that is being put in place to protect Canadians' rights.
Further debate? Those in favor of Amendment NDP 4? Those opposed? Amendment NDP 4 defeated. Liberal 4, Mr. Fragiskatos.
Thank you, Mr. Chair. What this amendment would do is clarify that when conducting reviews, NCIRA has access to all information except cabinet confidences. That would include information that is subject to common law privileges under the law of evidence, such as police informer privilege. The intent was always for the agency to access this information, but this makes it, but making it more explicit removes any potential for disputes should they arise in the future. Bill C-58 finally makes explicit reference to privileges under the law of evidence, and it raised the possibility that the absence of such language from this bill, Bill C-59, could be interpreted as suggesting a lack of access. As such, the need to make the review agency's access clear is here with this amendment.
Debate? Seeing none, those in favor?
I have a few questions. I thought perhaps, all right. Oh, I would require a bit of clarification. 9 and 10 are the same thing, I think, or pretty close to it. I think it was Mr. Davis that might respond to this. Clarification on the position that the government is taking. We have a certain nuance here as to cabinet confidentiality. So perhaps you could explain the technicality of the argument that's just been made.
With this amendment is to replicate exactly what was already in the CSIS Act in terms of access to information covered with under common law privilege. So when C-59 was drafted, it's just an oversight from the CSIS Act, and we didn't want any confusion that there would be any lack or any differential access for a review body that the Security Intelligence Review Committee enjoyed. So that's all we're doing is fixing an error in drafting when C-59 was created. And I think this issue was raised in other amendments I know coming up, and it was raised during committee hearings a number of times. But it looked like there was a less access, and that was not the intent.
Chair, I guess is it possible for you to comment then on the differences of this amendment, Liberal 4, and then the 9 and 10 that we have coming up? I know we haven't got to them yet, but the implications, what are the differences? Before we vote on this one, is this going to have implications on 9 and 10 coming up?
Yeah, it's just drafting language in terms of CPC. Well, I don't know if we want to jump ahead to CPC 9, but the words or but are used in CPC 10 and versus CPC 4. It's crystal clear on that the information is subject to any privilege under the law of evidence. It was just drafting differences.
Thank you.
Mr. Chair.
Mr. Fragiskatos.
With respect to CPC 9 and 10, I think the real similarity lies in Liberal 5, which I'll be speaking to in a few minutes.
Debate? Those in favor of the amendment? Those opposed? Amendment passes. CPC 9. Mr. Paulus.
C'est ce qu'on vient de parler dans le fond.
Well, we've just discussed it in a sense. It's very, very similar to Lib 4. This is why we wanted some explanation to ensure that that the difference between CP 910 and would it have any negative consequences or the same consequences, or it's moot at this point. A technical question, if you will. CPC 9 and 10, if they're covered by Lib 4, we'd like to know from a technical point of view if these become, as I say, moot, or if there's any debatable points of difference between that. Is that clear? I don't know if that's clear or not, but anyway. Okay, we've covered Lib 4, we accept it. Now, content-wise, substantively, we can see that it is similar. Are the results or consequences identical or not? Do we propose it nonetheless or not?
Mr. Davies, do you want to respond to Mr. Fuller's?
Well, just as was mentioned, CPC 9 and CPC 10 are accessing common law privilege for the complaints function, which is picked up in Lib 5. So in terms of apples to apples, that they're both talking about the same thing. And I go back to what we think is just clearer drafting language in Lib 5 in terms of despite any other act of parliament and any privilege under the law that ends and subject to, it is clearer than CPC 9 and 10 when you're using and or but.
Ms. Dema.
Question, is CPC 10 and Lib 5 not exactly the same? They're exactly the same, aren't they?
According to my records, they are.
CPC 10, despite any other act of parliament or any privilege versus Liberal 5, despite any other act of parliament and.
Okay.
So did he take that in? Okay. Does it say?
Okay.
Mr. Chair, just to clarify, am I right in asserting that CPC 9 and 10 are in fact textually identical?
Et la 5, Lib 5 est identique.
Lib 5 as well.
The button and never mind.
One's a button, one's an and.
Okay.
Okay, Madame Dema.
3 amendments are very similar. I'm just wondering if the officials could say, what's the best wording on this? Because we're talking about ands and ors and buts are the only difference between these. So which is going to capture what we all have the same intent.
Yes. Mr. Davies, I think you've already commented on that.
Okay.
We believe Lib 5 captures the intent.
Okay.
Any further debate on CPC 9? You're wanting to debate or you wanting to vote?
I have just one question.
One question.
From a legal perspective, from our experts in the room, is there a difference between and, or but? From a legal perspective? Seriously. And that's, we need to, I think we all have the same intent. So we need to determine what language we want to use that all has the same intent.
Who wants to answer that question?
Not particularly, but I think that our drafters would probably tell you that and is sort of comprehensive. So both elements, are included in the sentence, or maybe, just parses it out, says this or that. Honestly, I think either way you would achieve the intent, but our drafters tell us that technically an and is more appropriate than an or in such a statement.
And/or.
So, have we got clarification there, Mr. Motz?
Sure.
Thank you. Any other debate? Those in favor of CPC 9? Those opposed? CPC 9 is defeated. CPC 10. CPC 10. Again, it's Mr. Motz.
It's the same as we've been discussing in Lib 4.
And you were satisfied with the clarification before? You're satisfied with clarification now?
Yes.
Okay, good. Any other debate? Those in favor? Those opposed? CPC 10 is defeated. Excuse me. Liberal 5, Mr. Fragiscatos.
I think we know what the intent is, but I can justify it if you like, since there's so many similarities between 9 and 10.
I'm in the hands of the committee.
I can go into it.
Yeah, do you wish to speak to it?
Sure.
Just introduce it at least.
What the amendment does is clarify that when investigating complaints, the review agency has access to information that is subject to common law privileges under the law of evidence, not otherwise named, such as police informer privilege. The intent was always for the review agency, again, to access this class of information, but making this explicit removes any ambiguity. Finally, Bill C-58 makes explicit reference to privileges under the law of evidence. This raised the possibility that the absence of such language from Bill C-59 could be interpreted as suggesting a lack of access. This amendment avoids that risk by making the review agency's access clear in legislation.
Debate? Palouse.
Là, j'ai un problème de traduction parce qu'actuellement.
Well, there might be a translation problem then, because CPC 9, the French version is identical to Lib 5 in the French version. So we should, in fact, vote against Lib 5 as well then. The English version is slightly different. The French version is identical, and it's word for word. And if you rejected and voted against CPC 10, you have to vote against Liberal 5.
Yeah, CPC 9. On vient de voter contre.
I've just received a French lesson 101, and I'm going to leave our legislative drafter to explain why the problem that you've identified is not a problem. Go ahead.
Oui, vous avez raison quand vous dites que les versions françaises sont...
Yes, you are quite correct in saying the French version is identical. However, often in English we have to have a greater degree of precision as to and/or. In French, the et is understood and implicit to contain the or. However, in English, it is either and or. Well, we don't need it in all cases. Well, let me see. I'll have to think about that for a minute. I'm not sure if I follow, because it strikes me as a, ou, and or privilege under the law of evidence, for example. I don't see this distinction that you're making, because to my mind, and or are different concepts. So, despite any other act of parliament, and privilege, law of evidence, or. So, if you want more clarity, you have to keep CPC 9. Well, we have specialist terminologists and translators for that. But those who actually drafted this legislation and the wording of the amendments, etc., were very, very careful indeed to make sure that the sense of the language was the same. On the one hand, you have and/or, and/or. It occasionally occurs. If you take a look at some federal acts, you see and or will be translated the same way in French. It does exist.
In terms of, I mean, as someone who's bilingual, I try and go through both versions. It's not always possible because it can be a time-consuming thing. And so I'm just wondering, regardless of, and I'm okay to be corrected on the difference being different in French, but the fact is that the wording is exactly identical, and procedurally an identical wording would mean that the follow-up one would be amended. And so I'm just wondering, in terms of our privilege, especially for French-speaking members, how that plays in, and if that means that the Liberal 5 is even in order.
Have the Mr. Palouse is
Exactement, parce qu'actuellement, moi, je lis pas.
Precisely so, because I don't even look at the English version necessarily. I'll be looking at the French one. And Lib 5, CPC 10 are identical in the French version. In English, you have the or and. and the and. But we're voting on an amendment today, and I would be voting in French for the amendment, and both are identical. So I think that if we rejected CPC 10, we should reject Lib 5 in its French version.
A question for the clerk, and then if you look at CPC 10, Mr. Paul Hoos is exactly correct. It says A. It doesn't say mais. So if mais actually includes the word and as well, then 10 is wrong. So I'm wondering if Lib 5, can we amend the French version to say de la preuve est sous réserve de l'art? Can we change mais to A? Not in Lib 5. It says mais. Right, it should be A in Lib 5 though, right?
No, it is A.
Not the one I'm looking at.
Lib 1 has the same.
Which one are you looking at? It says in the.
Because they're different in English, but in French they're exactly the same.
Right, but so Lib 5 in the French version, in the very last line, where it says mais sous réserve, it should be A sous réserve, right? No?
It replaces or. The debate is.
But this is wrong here.
But they're talking about this.
Excusez-moi pour un moment, s'il vous plaît. We're crawling towards a solution here. Mr. Paulus, and then we'll ask our clerk to comment on it.
De façon très simple, Monsieur le Président.
Quite simply, Mr. Chairman, if you take a look at number 9, we have the mais, but. In 10, we have and, and Lib 5 has inverted that. They have mais.
The good one, or A is the good one. Just have to vote for the conservative one, depending which one you want.
Monsieur Picard.
I asked for a 5-minute break so we can discuss the nuance of gray on this one and agree on the one version. The idea of the legislator is there, it's just the word yes, and then we have, with the help of the expert, we'll manage to find the proper wording of something that seems to be the exact same thing.
We can't go backwards though.
Okay, I'm prepared to suspend for a couple of minutes and see if we can sort this out. I think it's well, I can have Mr. Mott's weigh in here. Yes.
Obviously, I'm not a bilingual expert, but I'm curious to know from those officials that are here whether they've encountered anything similar in legislation where we would have this disparity between and, but, or, and then that would maybe weigh in on our suspension.
Okay. I'm happy to do that, but I think the suggestion that we work this out on a offline for a couple of minutes is actually a good one. But so
I'm not disputing that.
Yeah, we'll respond. Well, first of all, ask the. Are you directing to Ms. Beecher or Mr. Davies?
do you have any views on
She seems anxious, okay.
In my experience in legislative drafting, it does happen that the French and the English are not direct translations of one another, but rather the operative words, are not the same to achieve the same effect. In the case of the mais as opposed to the et, I think we have less to say on that. I think that's maybe for the committee to make a choice on that particular word.
Okay. So let us suspend for a couple of minutes and don't wander too far away. please. Meeting's back in order. We think we have a procedural fix here and a linguistic fix. So, Monsieur Picard will move a sub-amendment to the amendment, and then we'll vote on the sub-amendment, and then we'll vote on the amendment.
J'aimerais rapporter un commentaire avant de proposer.
Small comment before I present my sub-amendment. We agreed among us to have identical translation, if you will. The spirit of the legislator is to be inclusive, and according to all that we've heard and discussed here by the experts, I propose the following sub-amendment. That in line 5, the English stay as such, and in the French version, to change the word mais for the word et, but for and, so that, in fact, it resembles the French version of CPC 10, and yet standardizes, if you will, the comparative value of the English and the French in Lib 5.
Le sous-amendement est de changer le mais pour un et.
Okay.
So the sub-amendment is simply to change a but for an and.
Okay, so that we all understand the sub-amendment being moved. In the English, it'll be and. En français, et. Correct? Okay. Okay. In spite of my pronunciation, people understand what is moving?
Sounded
okay.
good.
First, Monsieur Picard is so moved. Debate? Is there any debate? Mr. Dubé.
Juste rapidement, je ne veux pas retarder les choses plus qu'il faut.
I don't want to slow down things anymore at all, but I'd like to indicate the importance of the correct translation for any parliamentarian who works only in French, for example, but I do support the sub-amendment.
Sub-amendment passes. Now we've moved. Is there any further debate on the amended amendment? Seeing none, those in favor of the amendment as amended? Again, such harmony. Okay, that deals with Lib 5. We are now into Lib 6. And that would be Ms. Damoff.
Thank you, Chair. Just before I start, I just want to say to my colleague, Mr. Paul Hughes, good catch on that one. Thank you. The previous, thank you. On this amendment, it is something that certainly I feel very strongly about, and we heard a lot of testimony about the need for the ability to coordinate the review agencies, and so involving the Privacy Commissioner. However, I do believe that Ms. DeBrusen's amendment, Lib 7, is better written than mine, so can I withdraw my amendment?
You are the mover of the amendment. You therefore can withdraw.
So I will withdraw mine to support Lib 7.
Okay. But don't need any debate or vote. Thank you. Lib 7, Ms. DeBrusen.
So, as Mr. Damoff started with, this amendment goes to coordinating reviews with the Office of the Privacy Commissioner. And what it would do is prevent an unnecessary duplication of work. But it also, sometimes, even though the Office of the Privacy Commissioner isn't a national security review body, it does sometimes have some things that would cover the same ground as a review agency. So this allows for the coordination. And so I would propose that we support Lib 7.
Mr. Dubé.
tentatively support it. I just want to make sure there's a few questions I had. I don't know if Mr. Bruson can answer, or perhaps the officials, but Ashley mentioned the Privacy Commissioner's mandate is different and perhaps larger in the sense that it's not only about national security. And so some of these things, when there's overlap and such, and the fact that the findings of the Commissioner and the review agency may be different, I'm just wondering if by putting in place a legal framework to avoid duplication, that we also potentially push out conflicting but necessary reports and findings from the two bodies, while respecting the spirit. And as Ms. Damoff said, it is something we heard a lot of concern about, but I just want to make sure we're not hamstringing one body or the other in trying to achieve this objective, especially when there's overlap outside of the realm of national security and with regards to the Privacy Commissioner.
You directed your inquiry to Ms.
To whoever
Rosen,
could provide information that will help.
And do you want to respond at all?
I think Mr. Davies had his hand
Mr.
up.
Davies, then Mr. Motz.
Just to say that the system doesn't prohibit duplication. It's really legislative changes to encourage cooperation, ideally with the intent of avoiding duplication. They may still want to do studies on their similar topics, but it's to ensure that it's not the same group going the same week to talk to the same staff.
Yeah.
So when we say to avoid any unnecessary, that's sort of the safeguard to allow them to do the work nonetheless, while pushing them in a direction of collaboration.
That's correct.
Okay, great, thanks.
Mr. Motz.
Thank you, Mr. Chair. Far be it from me to pit my two Liberal colleagues against each other on this amendment, but I'm curious from the official's perspective, from the intent of what we're trying to do with the amendment, which language fits better with the intent? Like, which one do you think is better in your opinion between 6 and 7?
I dare say that their opinion will be...
Yeah, well, we believe that Liberal 7 and 12 together combined are very helpfully encourage a good two-way flow of information with the view of instilling cooperation. Allows them to share classified information to the extent necessary to avoid duplication, and also takes out of the equation the complaint process, so they're not tripping over each other or sharing information related to complaints, given there's a quasi-judicial sort of angle to the complaints process.
Yeah, thank you.
Further debate? Those in favor of Lib 7? Those opposed? Amendment passes. NDP 5.
Thank you, Chair. So right now the provision requiring the Canadian Human Rights Commission to be consulted uses the wording "if appropriate," and so my amendment seeks to have the review agency consult with the Commission to outline guidelines that would codify the way in which they consult them and not have it more ad hoc with the "if appropriate" wording.
Debate. Mr. Motz.
Well, it depends who you listen to. There are some who might suggest that there has been some questionable decisions by the Human Rights Commission, and they've made some great ones as well. So I'm wondering, I guess, do they have the expertise to deal with these sort of issues, to make decisions with respect to what this act is about?
Mr. Picard.
No,
Do you want to deal with the question first? Sure. Mr. Dubé.
They would be establishing in which cases it's appropriate, so it would not be something binding, and it would be for opinion or comments under subsection 1. So the Human Rights Commission wouldn't be having any kind of veto or whatnot. It would just codify the way in which they would be consulted by the review agency to offer that expertise, but it obviously wouldn't have any kind of consequence that Mr. Motz might be alluding to in his remarks.
Mr. Picard.
La référence au commissaire
Well, a reference to the commissioner and how he arrives at the decision, of course, is the same approach than the review agency. And I think that the capacity to determine what is appropriate or not appears to be adequate, and to avoid any slowdown in dealing with complaints, I think that it has to be determined which are appropriate and which are not in submitting them to the Human Rights Commission. So I would vote against.
Those in favor of NDP, sorry?
If I may, before we move to the vote, I just want to say that, on the contrary, I find that doing it on an ad hoc basis, judging if it's appropriate, is what would become cumbersome, whereas I think establishing it in advance and consulting with the Canadian Human Rights Commission would allow for that process to be properly delineated as the review agency, moves forward with its mandate.
Thank you. Further debate? Those in favor of NDP 5? Those opposed? NDP 5 is defeated. NDP 6.
Merci, Monsieur le Président.
Thank you once again, Mr. Chair. The amendment aims to provide to the agency the capacity to make orders, to ensure that there is compliance on the part of other security agencies, compliance with the law. This has been pointed out in a number of briefs that we received in the testimony of various groups, civil libertarians for the most part, to make sure that the accountability for their behavior is in fact imposed on these agencies. I find it very delicate to increase the authority or the powers of the agency, because when they start to get involved in operational matters without full knowledge of the context and the environment of those operational facts, might hinder the operations. I think it would risk some operations in some respects. So I think that we have to contain the authority or the power of the agency. Well, would it not be up to the minister to give directives in that vein rather than the agency?
For Mr. Dubé.
You're not going to. Yeah. So, which one is Mr. Davies? Is that the?
So whether the question.
Ma question était pour Monsieur Dubé, mais.
The question was, in fact, for Mr. Dubé, but perhaps Mr. Davies could answer it. But would that not be up to ministerial discretion and not the agency?
To do what? I'm not following what the minister would be doing here. So, in terms of issuing a report to the agency. Exactly. I mean, ministerial direction is essentially orders to their department or agency. So if the review body's findings concluded in a certain area, the minister could come over or could issue a ministerial direction to change internal procedure, reporting to him or her, and so on. So normally the minister would retain accountability here.
Mr. Are you finished? Are you satisfied in your inquiry?
Yes.
Okay. I gave a good answer. Good. Mr. Dubé.
Thank you, Chair. Just addressing a few of the points that have been made. There's nothing here talking about any of the specificity that Mr. Picard alluded to about operations. What it is too often we hear ministers, even though our parliamentary system requires ministerial accountability, whether it's an Auditor General report or any watchdogs report saying we accept the recommendations, we hear that day in and day out every time reports are tabled. And so in keeping with our tradition in the NDP of asking for some of these watchdogs, like the Privacy Commissioner and others, to have more teeth, I believe that the ability to make orders requires that there would be follow-up in keeping with findings that might be less than advantageous to the to the different agencies in the event that there would be a serious breach of Canadians' rights. I think giving the watchdog the ability to make orders to follow up on that is appropriate. They're not getting involved in the day-to-day activities. They're simply requiring compliance with laws and applicable ministerial directions. I don't think this comes into contradiction with the minister's ability to also require the same things. But as I said, I think that giving these watchdogs more teeth is better for Canadians.
I guess the caution I have, or the concern I have with how this is worded, is that we have the possibility that, the appearance that maybe the oversight committee is actually in charge of the agencies, and I'm concerned about that, because they're not. They are an oversight body. An oversight body reviews the activities of an agency for compliance, as is already in the Act, but to make then recommendations back or to make orders to ensure, to me, it says, okay, then now we are directing that agency. And I don't think that's the role of NSRA at all. I don't think that was how it was ever intended to be. And that's how I would take this, and I certainly defer to our experts on how they might interpret that.
Further debate?
Well, just
Okay,
the phrase "to make orders" definitely brings you into real time. It brings you into oversight versus the review body's mandate set up now in the Act is looking backwards, looking at performance relative to ministerial direction and compliance with the law. So the concept of orders puts you more into an oversight entity.
Thank you.
Further debate? Seeing none. Those in favor of NDP 6? Those opposed? NDP 6 is defeated. Lib 8. Mr. Francescatos.
Thank you, Mr. Chair. Reasonable amendment here, I think, without question. This amendment requires the review agency to suspend a complaints investigation if it determines that the investigation would interfere with an ongoing criminal investigation or proceeding. This sort of complaint could arise if the review agency was investigating a complaint against the RCMP, the RCMP's own independent review body, the Civilian Review and Complaints Commission, is currently required to suspend its investigations for the exact same reason. The goal here is to ensure that the review agency's activities don't conflict with the work of the police. Suspended complaints investigations would be resumed once the conflict was resolved.
Debate? Mr. Dubé.
Thank you, Chair. I'm leaning towards opposing this amendment because we came across this problem when we debated Bill C-22, creating the Committee of Parliamentarians, this notion about ongoing investigations. We look at a situation like the Afghan detainees or Air India, where those investigations could have been subject to this type of provision. Interestingly, often some of our opposition amendments are rejected by those on the other side on the grounds that these things are understood and built in more subjective ways into the legislation. And this time I'll be the one deploying that argument because I believe that it's understood that these review agencies are doing after-the-fact review at any rate, which is part of the rationale for rejecting my previous amendment about making orders which crept into oversight territory. And so I believe that given that it already has a review function and the fact that this kind of amendment could infringe on some of the more serious cases we've seen in Canadian history with regards to things spanning decades, but where investigations were ongoing, and this argument could have been made by authorities in those cases, and so I don't think that it's at all appropriate. And as I said, I would refer folks to the debate we had on C-22 with the Committee of Parliamentarians, where we heard evidence to that effect as well.
Thank you. Mr. Mott.
Thank you, Mr. Chair. I think where I have some issue with the new amendment is that it's in the agency's opinion. Obviously, I mean, they're going to be, I guess, biased in the fact that, and that's the wrong choice of words, but they're involved in an investigation. And how are they going to know that that investigation actually hinders or compromises an investigation that's going on with one of the security agencies, unless that security agency really is the one who gives them that information. So it shouldn't be in the opinion of the review agency. If anything, it should be in the opinion of the national security agency that's actually doing that has an investigation that might be compromised. Is how I would interpret that, or how I think it would make better sense to me.
Mr. Gatos. Thank you, Mr. Chair. I just boil it down to the main goal here, which is to make sure that the agency's activities don't conflict with the work being done by police. And I think it's important to have that, and I think this amendment would achieve that. But I can assure you that we'll agree to disagree, and we should probably put it to a vote. Get on to the next one.
Mr. Palouse.
Going to need some explanations because I think there's a bit of a contradiction here. If there's some operation underway, if you're reviewing operations of another agency, we say back off because this is interfering with operations. But the whole mandate was to make sure that you're doing the job right. There has to be some intervention, but I think the oversight agency's responsibility is not to hinder any operations. They're there to observe, to monitor, as it were. So I really don't understand the objective here. Perhaps our experts can explain that, the objective here, because that's to take away the responsibility from the agency itself. I'm sorry, Mr. Chair.
Is that the investigation would be suspended only in the context of complaints. Okay, so an individual puts a complaint to the RCMP, didn't like something. That investigation could be suspended if there is an ongoing criminal investigation at the same time, just to give pause to the complaint so there's no interference in the complaint process and the criminal investigation. It does not suspend reviews, so reviews could keep going on. The review body could keep doing its work. There's no provision to suspend a review.
Mr. Palouse?
C'est pas encore clair. Well, it's still not clear to me that the oversight agency or review agency would stop if there's a complaint. Can you give us perhaps a concrete example, if you could?
First of all, I would say that the Civilian Review and Complaints Commission, the CRCC, which is the existing body attached to the RCMP, they're the ones who were quite concerned that that language in their act, I guess in the RCMP Act, wasn't ported over to C-59. So they're the ones who brought it up as very important. I'm not familiar with specific examples where this was used. It's probably more in the normal civilian complaints relative to normal, police behavior. But they thought it was important enough to include just in case there was a need.
Mr. Watts.
I agree with the intent of 27.1, your amendment. I think it makes perfect sense. What I don't agree with is that the review agency actually makes the determination whether they should stop it or not. From a non-national security perspective, I've actually seen this happen where you might have, in the civilian police perspective, where you have a complaint made, but that investigation on the complaint made against a member or members or a team is actually going to compromise an ongoing investigation, whether it be drug-related or some organized crime connection, and so the agency, the heads of the agency, will know that they know enough about that they will go to the investigative body and say, listen, can you just suspend this until this is done? Because that investigation, you talking to people, will absolutely interfere with this investigation over here. So all I'm saying is, I like this. I think it makes perfect sense. I think this has to be in this act, but it should not be at the agency's discretion of who's doing the investigation, or doing the review. It has to be, however we change the language to mean that in consultation with the agencies that are actually doing the criminal investigation, or at the advice of So it can't be, to me, it makes no sense that the review agency is the only one that makes that determination. Because how will they know the nuances of the investigation going on by the police in this circumstance on a criminal matter unless they're told? And if they're told, then that should be in here. Like, it should not be the agency's opinion that it's going to compromise it. It has to be the police organization who's doing that criminal investigation. It has to be their opinion, because the review agency is not going to have all the facts. They're not going to have all the nuances of that that undercover op or whatever it might be going on. They're not going to know it. They aren't going to know the complaint aspect of it. And so that's where I agree. This is language that we have to have. It's just, I can't, it doesn't sit right with me that the agency actually it's their opinion, because their opinion in this matter shouldn't matter of whether it interferes. It has to be the agency where the police of jurisdiction is having a compromise.
Make amendment to the amendment.
Picard and Madam Damon.
Mr. Chair, thank you. I wanted to build on the commentary by Mr. Motz. He used a number of times the word interfere, and I wanted to direct my question to Mr. Davies and to look at the threshold that's actually in the language. The language isn't interfere. The language is compromise or seriously hinder. In my view, that's a higher threshold than simple interference. Any law enforcement agency is going to see some sort of intervention by NSIRA as an irritant or as interference. But interference itself isn't enough to stop it. It's compromise or seriously hinder. And I wanted to ask Mr. Davies his view on that threshold and also on the agency's capacity to assess objectively whether that threshold has been reached.
So my understanding in the CRC context, it's well understood. It's a back and forth with the police agency and the CRCC. It's not a one-way sort of decision. There's information exchange, and the threshold is met. I guess the concern is if the police unilaterally had that ability to shut down complaints, that may cause a concern as well. So, I think that if it's working well now under existing law, and it is clear that it is a discussion to get to that opinion, and obviously the police would have an incentive to ensure enough information was exchanged to help to get them to that opinion if it was necessary, then that is the spirit on how it was drafted.
Mr. Picard. Okay, Madam Damon.
Just a brief point. The wording for this is actually the same as what's in the RCMP Act. So the benefit of sitting beside the analyst. It's exactly the same if in the Commission's opinion, and then compromise and seriously hinder. So it's the same wording that we've used in other legislation, just for point of clarification.
Thank you. Mr. Paulus.
Monsieur le Président, moi j'aimerais demander
I would like perhaps a little suspension of 5 minutes so we could take a look at this amendment and see if we can improve the wording.
This is how far we've gone, and this is how far we've got to go. So I'm a little hesitant to take time out. I'm prepared to let the debate carry on, but...
Juste pour vous rappeler, mon cher président, que...
Well, with all due respect, Mr. Chairman, we have had this bill before the debate, and we haven't had too much time to work out all the details. So,
to ask for a suspension for several minutes. I don't think that's. We put it in the form of a motion, but I just want a sense of the will of the committee. Yes, no? Mr. Picard?
Was the purpose of the break just to phrase the amendment?
Proposer une rédaction d'un amendement à l'amendement.
Perhaps to prepare a sub-amendment to the amendment. It would take a few minutes.
Ms. Down?
I'm just wondering, is there any way we could sit till 1:30 to try and, I know it's last minute, no? Okay.
Only we...
Okay. All right.
So, are we in favor of a 5-minute?
Can it be even less than 5 minutes, Mr. Chair?
I can make it 3 minutes.
Sure.
If they're okay with it, yeah.
Okay. Suspended for 180 seconds. Now, colleagues, could you take your seats? Did the suspension of 180 seconds actually yield anything? Okay, good. Okay, can you speak to that, Mr. Motz?
Yes. Mr. Chair, I would propose the following, I guess, amendment or amendments
Sub-amendment.
to the sub-amendment in addition. So in addition to the language here, I would propose that the 27-1 as amended and proposed here read as follows. Despite any provision of this act, the review agency must suspend an investigation if, in the agency's opinion and in consultation with the relevant lead investigative organization, continuing the investigation would compromise or seriously hinder an ongoing criminal investigation or proceeding. So what we're adding there precisely is that there's a requirement to consult. And because this is not specific, that you could have other law enforcement agencies outside the RCMP who this could impact. All I'm trying to say is it's important that there is a clear understanding that the review agency will consult and that the decision to suspend still rests with them, but in consultation.
So just so that we are precise here, I wrote down in consultation with the lead organization. Is that the amendment?
With the relevant lead investigative organization.
Okay, with the relevant lead investigative organization.
And Mr. Chair, if I could indulge you to get some feedback from our...
Well, but we have to at least get the proper wording down first.
I'm impatient.
So, yes. So that is the sub-amendment. That is properly before us. So the debate is initially on the sub-amendment before we go back to the amendment. Mr. Motz has properly placed it before the committee. So debate on the sub-amendment.
I would ask the experts.
Do we want to go to the... we'll go to Mr. Davies first and then ask members for their comments.
I think the word agencies instead of organizations may be better. And the only concern I have with that is on the word investigative is maybe confusing with the investigations, this is about investigating complaints. So you see that in the act. So it's just want to be clear that we're talking about the investigative agency, meaning the law enforcement agencies in most cases here. That's the only thing when reading the concern I have.
So before we ask for further comment, are you open to those wording changes, Mr. Motz? So it would read then, in consultation with the relevant lead, what organization or agencies? With the lead agencies?
Law enforcement agencies?
Law enforcement agencies.
No.
Okay.
So we may need a minute to talk about this. I'm getting chatter behind me on law.
I see. Okay, well, before we get to the, we'll leave the wording as such for the time being, and maybe come back to friendly amendments to the wording. Meanwhile, we will debate, and the first one up is Ms. Dama.
Can you write it?
The opinion of the official, so I'm fine.
Okay, so that's, and Ms. DeBruzen.
I just have a quick question about adding in this consultation wording. Does it create a duty to consult when they're opening investigations? Like, I just want to make sure that we understand what type of burden we're putting here too. So,
well, my understanding is you're essentially codifying what already is going on. It already has gone on. That in terms of meeting the threshold and understanding whether the threshold is met, you would have to consult the lead investigator agency, to use your language, before you made your decision to suspend the complaint investigation.
and it would just be limited at that?
Yeah, so there always would be a lead investigatory agency.
Okay,
and you could maybe one suggestion, and in consultation with the agency leading such investigation.
Okay, are you still wishing to debate? Mr. Picard?
Je vais poser la même question.
I'll ask the same question, but I'll turn it on its head. If one has the choice to consult, not the obligation, but the choice to consult, in those cases where consultation may not necessarily occur, would that put any prejudicial pressure on the situation? An agency can have reasons to not want to consult, be it operational or informational. Are they legally obliged? And this would to consult. Otherwise, it might hinder the proper operations of the agency.
Complaint investigation. If you are undertaking the complaint investigation, why would you not want to find out more information, understand what the situation is before you suspended, right? So I can't imagine a situation where you would not want to do that before you made a decision to stop a complaint that you received. But
okay, I see no further wish to debate, but we still have not clarity on the wording itself. So if I could ask Mr. Davies and Mr. Beecher, Ms. Beecher, your proposed wording, so that Mr. Motz can either agree that this is a friendly amendment or not. So.
So the issue here is that we have a frequent use of the word investigation, referring to two types of investigations, and we just need to be precise. So perhaps it would be, if in the agency's opinion, start the amendment to the amendment, and in consultation with the agency leading the criminal investigation. And then I refer perhaps to the committee to work out the exact wording between the exact reference between the two mentions of criminal investigation.
Or proceeding, because we have to keep that same language in there, right?
Or proceeding.
Right. So I would accept that as a friendly amendment.
Okay, but I want to be absolutely clear as to what we're voting on. I wonder if you, Ms. Beecher, you could give that to Mr. Motz, so that we can all have a clear idea what or to the clerk, so that Mr. Motz can read it, and if he deems it to be a friendly amendment, then we'll be voting on Mr. Motz's amendment as amended by a friendly amendment. Ms. Dama.
We're out of time here anyway, but I really don't like making amendments like this on the fly, and I don't get a lot of confidence from the officials that this wording is the right wording to have. Mr. Dubé brought forward amendments where we said that it's standard practice, and so we voted against your amendments because that's what the agency's already doing. I'm hearing that it's standard practice. My preference, I think, is to vote against the sub-amendment rather than trying to draft something quickly that's going to stay in legislation forever. I'm just not comfortable doing it like this.
Mr. Police?
Compte tenu de l'heure, je propose.
Well, given the time, sir, I think that we could take the time to draft this sub-amendment, and we could leave it hanging there until the next time we meet. That we'll leave it at that, the sub-amendment.
After 1 o'clock. Therefore, we are now adjourned. We'll see you back for another round on Thursday, and then maybe after that again. Meeting adjourned.
Thank you.